We're talking about non-compete agreements in a segment called Protecting Your Assets with Sam Kreamer of the Kreamer Law Firm. All right, let's talk a little bit about trade secrets. How is that different or similar? How does that roll into the whole idea of non-compete?
A trade secret is something that is information. It's a formula, it's a way of doing things, it's a process, it's a document, it's a complete and exhaustive customer list. It's something that's important to a company. It gains its importance by being secret. And by secret, it means this information is not available to the general public. And you really couldn't get this information unless you invaded the company somehow. Now, there's a technical definition under the Iowa Trade Secret Statute, but from a 5,000-foot view, that's basically what it is. What the statute does is it protects a company from an employee or someone else misappropriating their trade secret. Now, misappropriation...
What does that mean? What does that mean?
Misappropriation is a term that's well defined in the Iowa Code, but for this purpose, I'm going to tell you that really what it is, it's a matter of protecting from theft.
Got it.
I mean, basically, it's somebody who knows or has reason to know that the information they're either using or giving to somebody else is a trade secret, and that they are misusing it, either for their own, they're using it for their own benefit or the benefit of someone else.
Well, how do you know if you got a trade secret?
It's not always clear as to what a trade secret is, and again, it's a case-by-case basis. Now, the Iowa Supreme Court has set out certain factors that it looks at in determining whether or not something is going to be a trade secret. I mean, for instance, there's the question of how important the information actually is to the company. There's the question of what steps has the company taken to make sure that it's secret, that it's protected. There's a question of how much the company has spent in order to develop this trade secret. How many employees have access to it? Again, these are not a finite list of factors, but these are things to be considered. One of the big questions is not only whether something is a trade secret, but there's a second aspect. And the second aspect is it has to be subject to reasonable efforts by the company to maintain its secrecy. So it's not
So
only...
something can't be secret if you're not really in there protecting it.
If you don't treat it as a trade secret, neither does the law. Now, the prototypical example of a trade secret is the formula for Coca-Cola. As it turns out, that is something that is not copyrighted, it's not patented. It is simply a formula that is kept secret by the Coca-Cola company. Okay? Now, there have been cases all over the board as to whether or not something is a trade secret or not. We would have to agree that customer lists are something that are really important to a company, right? A customer list may have all kinds of information about a customer. It may have the type of business the company's doing with them. It may have their names and their addresses. And if some employee walks off with that customer list, that could be really a misappropriation of the trade secret because they could walk that to some other employer. Well, it turns out that may not always be the case. Again, you've got a situation as to whether or not it's secret. Now, in a recent case, a employee walked out and solicited all of their clients with a former brokerage firm. Okay? And the courts looked at it and they said, oh boy, customer lists can be trade secrets. But they said, look, they said this particular case, it's not a trade secret. And they said it's not a trade secret because the individual didn't use the entire customer list. The individual only used the names and addresses, and the individual was successful in persuading the court that it didn't actually use the customer list, that the individual remembered who their clients were.
And much of that data is already available.
Some of the data is already available. Now, what can a company do to try to increase the likelihood that something would be held as a trade secret
Right.
and that something would be therefore protected from misappropriation. Number one, and the easiest, is to buy a $4 stamp that has the word trade secret and
Really?
stamp the document. Trade secret.
So bingo, it's a trade secret.
That doesn't necessarily mean that it is a trade secret, but it certainly establishes that the company's taking some steps in order to make it a trade secret. Second, companies that have these types of trade secrets often have policies and procedures manuals. There ought to be something in the policy and procedures manual which can reference this so that everybody knows, this formula or this manufacturing function, yes, this is definitely a trade secret and this is important. A third thing they can do is have employment agreements. Now, these employment agreements may or may not have non-competes in them, but they could definitely have non-disclosures in them. And they could say, okay, we specifically lay out that this recipe for creating birthday cakes, this is a trade secret to us, and under no circumstances is it to be disclosed. Again, a trade secret is something that is secret, meaning it is not readily available to the public. It must derive its value from being secret, and the company has to take reasonable steps to protect its secrecy. So
really three pretty basic things.
While they are basic, I believe it was Mark Twain who said, it's really uncommon how uncommon common sense is.
Yeah.
And so I think that things that could and should be done in order to protect these very, very valuable assets are often overlooked.